I'm Katie Spadoro with Cyber. It's Friday, May 29th, 2020, and I'm here with your Small Business Weekly HR Update. This week in your HR Update, 5 McDonald's employees have filed a class action lawsuit against McDonald's. They're stating that they allegedly were not provided adequate protection against COVID-19. These Chicago area employees have several complaints: that they were only given masks and gloves after striking, that they were given just one mask that had to be worn through the whole shift, and that they did not receive training on how to protect themselves or their customers. Additionally, the lawsuit claims that a manager at one location did not inform coworkers that she had COVID-19. The employees are seeking an injunction that would force McDonald's to supply adequate PPE and hand sanitizer, create policies that require employees and customers to wear masks, and inform employees immediately of any possible exposure. This lawsuit comes right after McDonald's released a very comprehensive 59-page guide for reopening, covering everything from dining room sanitation to how to respond to customers when they refuse to follow social distancing guidelines. Still, this is not likely the last of the COVID-19 lawsuits against major companies. Similar lawsuits have been filed against Walmart, Tyson Foods, Smithfield Foods, and Amazon. Overall, it definitely will be interesting to see how these lawsuits turn out. Next up, Sherwin-Williams will pay $3.6 million to settle claims brought by managers and associates that it failed to pay proper overtime and provide all meal periods, violating California law. This class action lawsuit includes over 5,000 workers and also included claims that the paint store failed to compensate rest periods and failed to fully reimburse work expenses. In this case, the employees brought their claims under the California law, but many of these allegations could also have been brought under the FLSA, which is often invoked for similar cases. This case involves automatically deducting lunch periods. The FLSA does not expressly prohibit auto deductions for meal breaks, but it does require employers to pay employees for all hours worked and to keep accurate records of the hours worked. Employers often get in trouble with auto deductions if they require their employees to work during meal breaks without pay, or if an employee works through their lunch break without permission or prior approval, but they're auto deducted for the time. As an employer, make sure that you comply with the FLSA and any state wage and hour laws. Reach out to Cyber if you need any HR help today. If you require that your employees take a lunch break, make sure that they are manually clocking in and clocking out for the meal period. If you have an issue with an employee who is working through their lunch break and that's against your policy, write them up. You have to pay employees for all hours worked, but you can definitely document a situation and discipline an employee for breaking a policy that exists. Next up, we do have another lawsuit involving the FLSA. Employers, take note, pay your employees correctly. Really important. In this case, Flour Foods, which is a baked goods producer that owns Wonder Bread, Nature's Own, and Dave's Killer Bread, has agreed to pay $8.3 million to settle claims that it violated the FLSA by misclassifying distributors as independent contractors and thus not paying them overtime pay. This was a class action lawsuit filed in 2015 in which the plaintiffs alleged that Flour Foods exerted control over their job responsibilities and that they should have been employees rather than independent contractors. The plaintiffs were required to arrive at the warehouse at specific times. They had no ownership or entrepreneurial influence over their day-to-day activity. The plaintiffs said that they should have been paid overtime when they worked over 40 hours in a work week. You should be very, very careful when you're deciding on how to classify workers as independent contractors. Most tests for independent contractor status center on the amount of control the employer exercises over that worker. The more control the employer exercises, the more likely it is that that worker should be an employee rather than an independent contractor. Typically, even a signed agreement indicating that a worker is an independent contractor may not be a sufficient defense. Getting this wrong can be very expensive, as it was obviously the case here. If you would like to hire some independent contractors, contact us. Make sure that you're running the duties test and make sure that you're covering your bases when you are hiring. Next up, we have another case that's involving the violation of the Pregnancy Discrimination Act. Again, we just spoke about this last week. In this case, a Pennsylvania site development company allegedly violated the PDA by terminating 2 employees because of their pregnancies. They announced their pregnancies at the same meeting with the president of the company. The president allegedly called one of them nuts and questioned the other one about who the father was and if she planned to get married. He asked both women if they planned to take leave. At this time, they were the only women working for the company at all. Both pregnant women were replaced, and they were replaced with 2 women who were not pregnant, one of whom was the president's wife. This is not a good idea. As a small business owner, you should be very careful about how you treat your pregnant employees. Pregnancy is a protected class and cannot be the reason that you terminate someone ever. If you need HR help today, contact Cyber. Lastly, we have a case involving the Age Discrimination in Employment Act, the ADEA. According to a First Circuit ruling, a Puerto Rico-based subsidiary of a global pharmaceutical manufacturer did not violate federal age discrimination laws when it consolidated a position and retained a younger woman over an older man. The unit was consolidated with another unit, leaving the 55-year-old without a job, and the 44-year-old woman was chosen for the consolidated senior marketing manager position. She sued, and she claimed that there was age discrimination. The appeals court affirmed that they had been given a legitimate, non-discriminatory reason for its decision to terminate the employee. The court determined that the woman's past experience with diabetes products, which compromised 80% of the company's sales revenue at the time, and strong recent performance reviews made her far more qualified for the position than the other employee. The ADA prohibits age-based discrimination against employees over 40. Employers often, unfortunately, set themselves up for age-biased claims when they reorganize and terminate or lay off those making more money who tend to be more senior. However, as this case shows, employers, if they have a strong defense and they can show they had a legitimate non-discriminatory reason, such as experience or performance for a termination or other adverse employment action, you should be okay. Cyber can help you document everything in case you need a legal defense. You could purchase a termination packet on our website and we can walk you through it hand in hand. Let us know if you have any questions. I hope you have a wonderful weekend. Thanks for checking out our blog and let us know if you have any questions.